Suddenly the recording is in progress.
Got it.
Why?
Can you see it?
Because they're recording the sessions. Okay, I think we can see it. And go on, let me make sure I keep control of everything, people coming in and out and everything, make sure, Francesco. Okay, Alessia, I think it's 05, so I think you should start. So welcome to this session. This is comparative law and economics session. The idea with Maximo was to try to have tentatively at least every year one session where we bring people doing research on the intersection of economics, law and economics, and comparative law. And because we don't know what's happened to Francesco, I think we were going to reverse the order of the papers, and we're going to have Alessia now. So Alessia, please go ahead. You have your 20-25 minutes.
All right. Good afternoon, everyone. It's a pleasure to present my working paper, should we call it Moral Money, Institutional Ownership, and Board Diversity. So the corporate world has changed considerably, and the rules governing it are in constant evolution and must adapt to their surroundings. The long-standing idea of shareholder capitalism has been challenged in recent years, and experts and scholars are calling for a redesign of corporate law and corporate principles. The resurgence of stakeholder capitalism and all the debate around it that reminds us of the 50s, 60s, and 70s, and its profound impact on corporate law and corporate governance can significantly change corporations, businesses at large, and society. So my work in progress approaches issues that have been highly debated for years from an old wine in new bottles perspective. Moreover, I examined the role of institutional investors in triggering positive adaptation and change in the corporate world by advocating for more board diversity. All right, so please tell me if you're seeing the PowerPoints. You should be seeing research questions. Just checking.
Yes.
Yes. Yep. Good. All right, so I want to start with these two research questions. Who should managers be accountable to, shareholders or society? Does the composition of the board matter? So what's my framework, my doctrinal framework? So I use the Burrell-Dodd debate. Burrell said in a very well-known paper that managers should be accountable to shareholders. Dodd, on the other hand, said that managers should have a wider responsibility to society. Now, the other paper that I used to frame my research is Martin Gelter's paper, The Pension System and the Rise of Shareholder Primacy. And in this paper, maybe I'll just, let me see if, is it better? Can you see it? Oh.
No, it's better. It's better.
Was it better or
yes.
No?
No, it's better if you make it a larger. Yes.
Let me see.
You make it a show. Yes, that's better.
Then I can't see my notes. Sorry, we'll have to do it.
Okay, go back if you want to see your notes. Okay, that's fine.
All right. So the other paper is Martin Gelter's paper, The Pension System and the Rise of Shareholder Primacy. And so in this paper, he explains that it is widely accepted that the objective of corporate law and corporate governance should be to promote the wealth and welfare of shareholders. The reason for this highly consequential statement is not efficiency, he says. Shareholder primacy is an unintended consequence of changes in the pension system. We see a transition from defined benefits to defined contribution plans. And so this change in the pension system has determined the consolidation of the idea of shareholder primacy. So as a consequence, pension wealth is no longer tied to the firm, it is tied to the capital market. And we see that workers' incentives to invest in firm-specific human capital seem to have decreased. And we also observe an increasing importance of pro-shareholder policies and enhanced shareholders' rights. And ultimately, what his thesis says in terms of the change in the pension system that we see in the United States is that there's an increased power of shareholders vis-a-vis the managers. So this takes me to talking about the rise of institutional investors. And it is fair to say that the changes in the pension system increased the significance of individual firms where pension wealth is invested. And those changes also put institutional investors in the spotlight. All right, here's a graph. And as you can see, this graph illustrates the growth of institutional investment from 1980 through 2009. So you can see how much it has grown, and the peak here in 2006, and then we get into the Great Recession. Then there's another graph that I want to share with you. So it illustrates that the share of institutional investors in equity investment also increased relatively, right? Namely from less than 30% to around 50%. So this is pretty intuitive. It's not a difficult graph. So this is interesting. So these numbers, these two graphs are interesting because the significant weight of institutional investors allows them to control the board in terms of decision making. And so the question is, can they influence board composition in terms of gender? And for me, this is an empirical question, and it is an economic question. It is an empirical question because we do not know how many women there must be on a board to shift the power balance. And it is an economic question because institutional investors will do what works for them and for their clients, right? So since I'm talking about boards, I decided to just give you an overview, right, of the institution, the corporate institution that I'm talking about. So we have three models. Two big ones, one-tier model or a two-tier model. So as you can see, we have the ownership level where you can see how the general meeting works. And then the steering and monitoring level and the executive level. So we have the board, and I'm looking to my left, the one-tier model. So then you have the board, which will have a chair or CEO. And then the two-tier model, which is adopted in Germany. By the way, the one-tier model is the one that we have here in the US. Then the two-tier model, you also have the ownership level, the steering and monitoring level, is undertaken by the supervisory board, and then the supervisory board will monitor the management board. And then we have another type of corporate board, the board of auditors model. Perhaps Paolo, I don't know, Italy might follow this one. Maybe you are familiar with this one. Okay, so these are the three models that you can find in the literature, and this is basically how a corporate board can be composed. And then there's this global perspective that I find really interesting. Italy, Japan, Portugal follow a hybrid multiple options model. So the legislation foresees that, welcomes that. Then for the optional, for one or two tier model, so we have Brazil, Czech Republic, Denmark, we have the Scandinavians here, Luxembourg, the Netherlands. The one tier model is followed by Australia, Belgium, Canada, Chile, Colombia, Hong Kong, and then the two tier model, Argentina, Austria, China, Estonia. So we have an eclectic number of countries that kind of follow different options. So just to give you a perspective, right, in terms of institution, corporate institution, and also in terms of choices that are made globally. All right, so the question here now is which model is preferable, right? So what are we talking about when we're concerned about board diversity, which is preferable? And when we talk about preference, we were also talking about challenges or features, particular features that our managers, board of directors will have to deal with, right? So the one tier model is composed of executive and non-executive directors. What may happen is that in the one tier model, the non-executive directors may be better informed. There may be less frictions between the two boards. It may be more flexible, cheaper. There are not a lot of transaction costs when it comes to monitoring and setting up strategies, right? Then when it comes to the two-tier model, what do we got? So we have a positive thing, which is a clear division of management and supervision, right? That may lead to a better control of management and avoid a conflict of interest. And in this model, you will also see employee participation, right? Like what there is in Germany with co-determination. Now, besides trying to understand if institutional investors can influence board composition, it is equally important to understand if in this debate, the end of progress is equal opportunities or equal outcomes. There is a huge difference with consequences for both justice and incentives that are rarely discussed. And I obviously welcome your comments to discover this, right? What do we want? What's progress? Equal opportunities or equal outcomes? All right, so when it comes to this question, equal opportunities or equal outcomes, there's a piece that is extremely interesting, gender composition of the upper echelons and firm sustainability performance. You can see on the screen, and the authors focus on the impact of gender composition of the board of directors and the top management team. Let's call it TMT. The TMT of business organizations on determining firm level sustainability performance in developing economies. So the authors define a firm's TMT as the top executives who have a vice president or higher title. And their case study is Turkey. So their contribution is informed by the upper echelons perspective, token theory, and the notion of critical mass and the literature of group effectiveness. So as we know, Turkey is characterized by a traditional society where gender roles are strongly predetermined and affected by high conservatism. So consequently, achieving firm level sustainability performance through gender diversity in corporate boards and TMT is a greater challenge in that country. So the idea inherent to the upper echelons perspective that the authors use is that the characteristics of a firm's top executives will inevitably define the firm in terms of corporate social responsibility and sustainability performance. So we're talking about the outcomes, what are they doing? So they focus on corporate social responsibility, sustainability performance. How does the composition of the board achieve the best possible goals in that context, right? So the authors start from two hypotheses. Hypothesis one is the following: there is a positive relationship between the critical mass of women executives, at least 3 women on the TMT, and firm sustainability performance. And the second hypothesis sets forth that there is a positive relationship between the critical mass of women directors, at least 3 women on the board of directors, and firm sustainability performance. So as Akar and Gozum analyzed a sample of top performing 100 firms on the Istanbul Stock Exchange, they discovered that the composition of these companies, these 100 companies, and board of directors, based on data in the public disclosure platform, they discovered that the size, the profitability, and sustainability, among other elements, were extremely important to determine the role of women in those firms. And they concluded, in line with hypothesis 2, that there seems to be a strong positive association between sustainability performance and firm size and presence of 3 or more women directors on board of directors. So again, firm size, larger firms, more gender diversity in the board of directors seem to be significantly associated with firm sustainability performance. However, the authors note that the positive influence on sustainability performance of 3 or more women directors on board of directors is only marginally significant, possibly due to the small size of the sample. So their piece is valuable. So the piece that they wrote is valuable because it calls our attention to the role that women can play in the board of directors when it comes to ethic decision-making and responsiveness to stakeholder demands, which for the most part are interconnected with the sustainability goals. So my conclusion, it seems to make sense, at least for me, to streamline my research based on 2 assumptions. First, institutional investors can influence the board composition in terms of gender. Second, the end of progress is equal opportunities rather than equal outcomes. And I suspect that the type of incentives that must be designed to enhance equal opportunities will trigger equal outcomes. That's it.
Thank you, Lesia. So I will now open for questions. Paulo, go ahead. I'll put myself on the queue too, but Paulo, go ahead.
Yeah, Lesia, I think the project is very interesting. This is some little suggestions. So like I miss in the presentation the link between different board structures, so the comparative analysis of different corporate governance structures. So like, the German, the monistic, dualistic system, and the American one, and the effect and relationship with diversity of the board. Maybe you have to spell it out a bit better, because I don't see a direct link between, for example, a German approach. Yeah, you can see perhaps, the unions having a stronger voice and pushing for more diversity on the board. But that, the German system is peculiar to Germany. In Italy was tried for a bit, and then like no corporation, to my knowledge right now, have it. Intesa Sanpaolo had it for a few years, and then they drop it because it was unworkable in the Italian system. So, perhaps a better link, and like how Germany and that system is peculiar. I don't know how much they're going to help you on your analysis of the role of institutional investors in pushing for diversity. And the other little question is, or suggestion is that, like, you build your analysis on Martin's work from like the early 2010, and so the role of pension fund. I think in the last 3 years, another big player are not just pension fund, but asset managers. They've been pushing hard for diversity. And this is just a suggestion to expand the paper to also look at that role that become more prominent in the past few years. In the past few years, asset managers has become like the main force that has supported the passage of some like green resolution, diverse resolution. So I think like, we've seen in terms of like passive/active investors in the market see that the role of pension fund was now took over by asset managers and some sovereign wealth funds. So I would suggest to look also at those roles. Like I know, for example, that the Norwegian sovereign wealth fund on one side has been divesting completely from non-green market or industries that cannot fit into a green-ish definition. But at the same time, have been very active in supporting for more diversity on the board. So like this is just like how to expand, in my opinion. Like you can expand a bit more the analysis, starting from Martin's work that look at the pension funds that back in 2010 were the most prominent investors and the largest shareholders in many corporations, to now who are the new pension funds. So the asset managers, those are the ones that now have a stronger vote and a stronger saying. But I think it's a very fascinating project. This is just like suggestion on thing that going forward in writing the paper that you can address.
Thank you. Thank you.
So if I can go ahead, I mean, my comment is a bit similar to Paulo, but I'll take it in a different direction, because I think once you start developing this, you may have a selection effect problem here, which I'm not sure if Pinar had her own selection effect in her paper, because the problem you have here is if you're going to try to have a theory, as Paulo was sort of challenging you to try to explain why some model of board is more friendly or less friendly for diversity, being that gender diversity, obviously that's the example you're using, but it could be any sort of other dimension of diversity. The problem you're going to have to think about is you're looking as if the models of corporate governance themselves can be correlated to different diversity outcomes. But the issue is the extent to which societies that are concerned with more diversity outcomes will adopt some sort of models of corporate governance that reflect those concerns. And so you may have the reverse causation problem here, and I think you'll have to think about it. If countries are, because when I look at your slide 9, I think, and you look at the countries around, the one you have the countries around the table, there is no obvious correlation with standard notions, as you know. I mean, if you look up common law, civil law, you're not going to find, very, very quickly where will this explain you. The one, yes, the pie, the chart pie.
Okay.
But you can see that some of, at least European level, some of the countries with the highest levels of equality seem to be concentrated, which are the Scandinavian countries, seem to be concentrated on the optional for 1 or 2 tiers, whereas countries with more inequality seem to be concentrated on the other side. And so it's unclear then if it's the boards that are creating an inequality or if it's inequality that reflects social preferences, which explains the choices of boards.
Right.
So have to think very carefully which way this could go. Because again, if you want to look at data later, even if it's descriptive level, I'm not even thinking you have to do regressions, but even at the descriptive level, you may have a serious objection, which is selection effect, that you're looking A implies B, when it could be that B actually implies A. So I think you have to think about that, how you're going to sort of address that, that problem.
Brilliant, thank you so much. This is so helpful. Of course, that this is you know, a work in progress. It's in its early stage, but definitely the thought of considering the type or the model of board and how gender can contribute to a more efficient decision-making process, or even if we're just, you know, thinking of gender as something that we feel is important, but at the end, the outcome ends up not being what we expect. So I'm still exploring these things, and the case study of Turkey is interesting because the authors, they depart from two hypotheses which are very similar, but one has to do with the TMT, right, with the executive team, and the other one with the board. And I'm kind of, you know, so they tend to say that equality of gender helps to have better outcomes. And so, but the society and what you've just said is super important. Thank you. No.
Paulo, one last comment.
No, just to follow up on what you said, I think like one aspect is important, societal preferences, but also the other big aspect is, you know, composition of the shareholder structure. So like, you know, you have some countries like Turkey where they have like not a super developed capital market. So you have a weaker presence of institutional investors and asset managers, and you have more controlling shareholders. So, you know, that can affect a lot of the analysis, and it's country by country. So it's difficult to generalize. And the other question, and again, like going to the board structure, I would like to see a bit more like, you know, and we can talk a bit more as like, why do you think that affect board diversity? Because
no, I don't think.
Yeah, no, I don't see the link between different board structure and diversity on the board as two link mechanism. I can see more, you know, how asset shareholders composition can affect diversity. And so you know, no matter how you organize, you can be just even like an LLC with many members, and you know, no matter how you organize, depending on who are the investors, that can affect a lot more than like how you organize. But you know, that's just something that perhaps I missed that link on how a board structure, like, you know, like an internal organization, can affect more women, more diversity on a board level.
Well, I don't know if the model of the board will affect the number of women in the board. But I'm looking at this PowerPoint. I don't know if you can see it. My purpose was to, when I talked about the model of boards, was to say that there are good things, right? There are advantages. On the other hand, a contrario, there are disadvantages, frictions, problems of communication, and so on. And I wonder if the actors change, right? If the actors change, some of those problems, those costs can be overcome, right? Or not. We do not really know. So this is why I found ACAR and Ozem's piece interesting, because they tend to say probably if we have at least 3 women on the board, on the you know, steering the decision-making process, the outcome will be better. But they also there's a sample problem there, because they analyzed 100 firms, and it is not a lot, right? It is not a lot. So it's more like how, not so much how the board structure will determine the number of women on the board, but probably, I think, if we have more women, the board will work better, there will be more positive outcomes. I think this is the way I want to go, but it might be that from the presentation, you could sense that, okay, let's see how the board structure will impact how many women we have. And it is a valid question. It is a question that it's possible to ask as well. I mean,
I think I misunderstood the presentation. I think you wanted to focus on the second aspect, and that's why I thought that you discussed all the different board structure and how different countries can place in different level. That's why I thought that that's one of the claims that you want to make. But if that's not what you want to make, it's fine. I understand, like there are great work on like how diversity can improve from, you know, many aspects of firms' outcomes. So like, you know, I understand that, and if the paper wants to engage with that, that's fantastic. You know, my only little doubt is like how it, just the board structure, and that's like your whole discussion about different board structure can affect diversity. That's a question that I cannot, you know, grasp completely.
Right.
But you know, it's that if that's not, you know, I might have just gone off rail.
Okay,
But
guys, we still have Frank with the question, so I think we should get all the questions and then Leslie the last word, and then we go to Francesca's paper. So Frank, please go ahead.
Okay, yeah, let me pick up just suggestions and start with illustrated by the last conversation. In terms of your paper and also for future presentations, I think it's important to start with, you know, what the thesis is a thesis that women on boards impact various measures of corporate performance, and then you're testing that against different types of board structure in different countries. Or is a thesis that different board structures in different countries impact the number of women on boards. That you want to start and make that very clear, is illustrated by the conversation. But it seems to be going beyond that. You can just do a sort of correlation study at random, but I think it's often helpful to have a theory of why something would be, and then look at the various correlation studies to see if it matches up at all with that theory, as opposed to just doing a correlation study. So, and I think that was the question. Let's go to does board structure impact the number of women on boards, board diversity? Well, you have to tease out, as you look at various countries, what countries that have some sort of legal mandate. I've come from not a country, but a state, California, that's now imposing a legal mandate for board diversity. It seems to me if I had a theory about board composition impacting board diversity, I would suspect more co-determination because of historical biases and structures of union and worker councils might have some impact there, as opposed to a supervisory versus an executive board and that sort of thing. And so having a theory to start with about what you expect to happen, because I don't understand what theory you have as far as two-tier boards impacting composition. Conversely, you know, if you're sitting there saying, well, the number of women on a board will impact corporate performance, why would you expect a different result in a two-tier board versus a one-tier board, depending on what type of performance? The original studies that triggered this came out of the financial crisis and the greater conservatism, and thus less problems for boards with greater diversity that didn't go hog wild and you know, and melt down as badly in the financial crisis. But why should that matter two-tier, one-tier? So have a theory of why you expect these things and make that front and center, I think, is what my suggestion.
Thank you, Frank. So I think the place where Paolo was coming is this. So first, I started the presentation asking whether there should be a responsibility toward what stakeholders want, including the society. And should managers be accountable to them, shareholders and society, or shareholders or just society? So what do we have here? Are they supposed to care about only shareholders? Are they supposed to care only about the society? Are they supposed to care about shareholders and society? And then a sub-question that I asked was to that end, to understand, to find an answer to that, does the composition of the board matter, right? Because the members of the board are the ones deciding whether they care more about shareholders or society. And then the other issue, because I think there are two issues here, and I think Paolo was referring to this one. The first that I've just said, does the composition of the board matter when it comes to responding to corporate constituencies' interests? So this is what Paolo was referring to. But then there is another issue, and there is is where I need to find a connection, I think. The issue is whether we care about equality or we care about outcomes. But, so I guess I have to find, like you said, Frank, a framework and a thesis that puts together these questions. Definitely. So thank you for your comment.
Can I follow up really quick? You're starting too broad. It would be my suggestion. The whole question about, stakeholder versus shareholder, it's just too broad. When you then narrow down, if you want to get into that thesis, you could ask the question about whether a greater gender diversity board produces more responsiveness to stakeholders or not. There may have even been some research, but then get to that question.
Right.
It's going through too many steps, and that's, I think, why there's some, perhaps confusion in terms of where you are. By the way, one other thing that I recommend, I can't give you the site because I don't have it. It's something presentation I heard some years ago, that the #1 driver in terms of gender diversity on boards, other than perhaps a legal requirement, was CEO attitudes. If a CEO wanted gender diversity on boards, it was a gender diverse board. If the CEO did not, it was not. And so that one aspect. One other quick cite for you is that the rationale for the California stat requirement is to promote a sort of stakeholder, in the sense that it would, a greater diversity on boards would eliminate or reduce gender inequality within the workforce. And that was so it was a sort of civil rights aspect in terms of its broader impact on down, and you should be able to find a site for that.
Yeah, but when it comes to civil rights, do we need to get into it in order to respond, to understand the importance of gender diversity on boards?
But that was the rationale that was given for the California provision, and that's all I'm just trying to tell you.
Okay, I think, guys, I think we need to move to the next paper. This was a wonderful conversation. I hope, Leslie, you got a lot of comments and feedback. But I do want to get the program back on track. So we actually reversed the order. So Francesco is here now. So Francesco, go ahead, and then we'll do the last paper. Will be last but not least, Paolo. So Francesco, the floor is yours if you want to share some slides.
Thank you, Nuno. I'm sorry for I was clicking on the wrong link, and I was finding an empty room, which was not a very encouraging audience. So I didn't want to have a monologue with myself. Okay, so thank you for sending me the correct link. So let me share the desktop here. I hope this is, yep. Okay. Can you see something there?
Not yet. We cannot see.
Sure.
At least I cannot see.
Oh my God. Okay, doesn't allow me to share.
You should be allowed to share. Hang on. Francesco. You're a co-host, so you should be allowed to share.
Can you see something now?
Yes.
All right.
It's working now.
All right. So this is a paper that, okay, I am tentatively co-authoring with Gianpaolo Frezza, who is the former dean and now provost at the University of Rome, LUMSA. Alice Guerra, who is a colleague in Bologna, and I am jointly appointed at the University of Minnesota Law School in Bologna, economics. Tentative title is Investing in Private Evidence. Oops. Motivation, comparative fatherhood. I am a father of 6 children, 4 live in Italy and 2 live in the United States, and Nuno knows several of them. And something I noticed when they come to pick me up at the airport, and I am in Italy, they all have dash cams, okay? And the mom takes care of their cars and their insurance. And I asked them, well, you know, what I didn't even know what these things were. There were video cameras on the dash of the cars. And I asked them, why are you using them? You know, they are really bad drivers. And I said, you know, this is terrible. You know, they are recording your bad driving. So I said, no. This is something we get a discount on the insurance. And every insurance company in Italy gives a discount, and many insurance companies in Europe give discounts for those who use the webcams. And in Italy, every insurance company is giving a discount. I Googled, and that's the information there. I take care of my kids in the United States, and my kids do not have dash cams. So I went back to home and says, hey, let's get a dash cam for your car so we get a discount on the insurance. And they said, Dad, there is no discount for dash cams. So I investigated, and that's the information I found, is that no insurance companies offer a discount if you have a dash cam on your camera. Okay, they will give you a discount, you know, only 1 or 2 if you have the snapshot. Snapshot doesn't record videos. They only track your driving pattern. But if you have an accident, there is no recording of what happened in the accident. Okay, so they cannot be used against you. The insurance company knows how you drive, but not what happened in that specific incident. Conversely, in Italy, they keep track of the accident, but it cannot be used against my kids for their bad driving. My kids speed, they are terrible drivers, but they are not penalized for their bad driving. Okay, there's only a recording of everything that happens. And if there is an accident, there is a recording. So, oh, weird. Okay. So that puzzled me. So how does the law explains these differences and the private investments? Because my kids actually spend money to buy these dash cams. And basically the insurance companies are subsidizing through discounts the investment in this private evidence technology. So that's what I found out, that in several European jurisdictions, laws have changed, or all laws have been expanded to create a presumption of negligence. If there is an accident for vehicles that are not guided by rails, or no trains, there is a presumption of negligence for any harm that has been caused by people or things while operating a vehicle. In Germany, since 2003, Denmark, sorry, 1998, Netherlands, 94, and some more recently. In Italy, we have a presumed joint negligence. So if there is an accident between 2 cars, or in the constitutional court since 1972, even a victim is presumed jointly negligent, so presumed comparative negligence. They need to prove to have met the standard of due care. So it's the victim that needs to prove the diligence, as opposed to the victim proving the negligence of the tortfeasor. I remember when I studied evidence, these burdens of proof were called probatio diabolica. Okay, it was something that a negative proof, proving to be non-negligent, was, you know, it was, hi Simon, it was called an impossible proof because you needed to prove to have done everything possible to avoid an accident. But the idea is that with new evidence technology, proving to be non-negligent equals proving to have been diligent. You have a webcam that shows that you were not speeding, that you were in your lane, that you were not reading a newspaper while driving, you were not on the cell phone. And most frequently, it is easier for the driver to prove that they were diligent than it is for the victim to prove that the driver was negligent. I mean, how can a victim prove that the driver is negligent? Most frequently, it is easier for an individual to document its own behavior than for a victim, prospective victim, to document the behavior of all infinite prospective tortfeasors. So there is a, you know, this probatio diabolica is a dogma that is fading away. Okay, conversely, in the US, the presumption in favor of defendants have been kept very solid. Incentives to invest in evidence generally fall on the party who faces the burden of producing evidence. So the adoption of evidence technology has been more limited. We don't see dash cams on cars. Insurance companies don't provide discounts for those who put dash cams, unlike in Europe. Again, snapshot is a technology that keeps track of patterns of driving, but does not provide visual records of specific incidents that are relevant for discovery in case of an accident. Okay, you cannot say, oh, show me your snapshot. Because snapshot can say, okay, you are a bad driver, but it doesn't prove that you were a bad driver in that specific accident, because it doesn't keep track of what happened in that specific moment. So very rarely we have had instances of subpoena of snapshot technology after an accident. Okay, more generally on evidence technology, technological and scientific innovation is rapidly changing the domain and reach of legal discovery. Instruments that can be adopted by private parties on a voluntary basis, examples are not only dash cams on cars, body or helmet cameras used by cyclists or police officers, black box recording or on robotic technology, Google timeline that tells you exactly where you were at any moment in time, various other telematic and GPS location technology, digital timestamp of recordings of cellular transmissions, certified cloud data storage, and archival systems by third parties where you cannot modify the email that you sent or received, fingerprint, face and eye recognition systems that tell you when you walk in and out of buildings, and other things. So good or bad as they may be in terms of security or invasiveness of our private lives, these new technologies have been transforming the information protocols and evidence standards of our times. Okay, when searching for evidence, parties and fact finders can use these technologies to acquire information about past events. Okay, and unlike the United States, European legal systems have changed evidence standards and legal presumptions to leverage the opportunities offered by these technological transformations. So in this paper and a series of papers that started from these observations, that started from my children. Simeon came in just a few minutes late. I was talking about my daughters in Italy and in the United States. Studying the effect of liability rules, legal presumptions, and discovery rules on the adoption of private evidence technology. So evidence technology gathers evidence. In any given case, access to private evidence technology can only benefit and never hurt the party who is faced with the burden of proof and persuasion. Okay, if I need to prove the negligence of somebody, well, if I have a video camera, that video camera can help me. If I cannot, if that video camera doesn't record anything useful, well, that's useless. But if there is something useful, that can benefit me. So the evidence technology can benefit the party who has the burden of proof. At worst, it will not benefit the party who has the burden of proof. Okay, ex-ante investments in evidence technology can be a double-edged sword. Okay, so if the evidence technology can be discovered and used against the owner of the evidence technology. So if the webcam that is on my kid's dashboard can be used against the victim in case of an accident, and my kids are negligent, okay, and in Italy there is the presumption of negligence. Okay, without the dash cam, the victim would have to prove the negligence of my kids. And the victim may not be able to prove the negligence of my kids without the dash cam. But with the dash cam, if the dash cam is discoverable, they could subpoena the dash cam and use it against my kids. Okay, so the question, okay, so the first analysis is here. Okay, in an ideal world, if you know that you are a prospective victim and there is and you have the burden of proving the negligence of the tortfeasor, then you want to, and so these are all the effect of the liability rules. In a simple negligence regime, the private evidence technology can only benefit the prospective victim. In a strict liability with a defense of contributory negligence, the evidence technology benefits a prospective tortfeasor. And in a regime of negligence with contributory or comparative negligence, benefits both parties. Okay, this is the different direction in which presumptions work. So this is what happened by introducing a presumption of negligence in Germany, Denmark, Netherlands, and now in the UK, there is discussion of introducing that as well. And the presumption of joint negligence that we have in Italy. That is why we have observed that switch by insurance companies to encourage the adoption of webcams. And we see webcams everywhere. Taxis and okay. Okay, but the problem is that with adversarial discovery, it becomes a double-edged sword. If you have a presumption of negligence, sure, you can use the camera to show that you were not negligent. But if you were negligent and the camera is discoverable, the victim can use the camera to prove your negligence. Okay, and that is where discoverability rules come into place. Okay, European legal systems follow a very conservative approach with respect to adversarial discovery. Okay, in the US, you could subpoena the webcam, say, give it to me, and you can do like a phishing. Say, let me watch the video. Hopefully, I will find something useful for me. Okay, even though you don't know whether you will find something useful. You don't know whether the driver was using the phone, whether the driver was distracted, whether he was scratching his head. You just subpoena the video, hoping to find some evidence that you can use in your favor. Okay, in European systems, you need to explicitly say the reason why you are asking for that evidence. Say, I'm asking for that evidence because I know that I can use that video to prove that in that moment in time, the driver was using the phone. You need to specify the reason why. So you are short of having the material evidence for something that you know is there. Like, I know that he was turning his head on the left in the moment. I know that he was talking to the kid in the back. And that will help me prove something I already know. You cannot generically say, okay, and do some phishing in the hope of finding evidence. So you basically have to already know what is in the video before being able to subpoena it. And that's the whole. So the ex post discoverability of evidence negatively affect its ex ante adoption. By making evidence discoverable, it will discourage the ex ante adoption of evidence. So the paradox is that the quantity of evidence made available to the fact finders may actually be larger when evidence cannot be subpoenaed. And that's one of the effects of adversarial discovery. The third part of the paper is the effect of evidence technology on the incentives of the parties. If you have videos and you drive carefully, your benefits of driving carefully are higher because you will be able to prove that you were driving carefully. So the wedge in the payoff of driving diligently versus driving negligently, the wedge in the payoff becomes wider. So evidence technology increases the advantage, increases the incentive to behave carefully. And so it has effects both on the care incentives and activity level incentives. And finally, there is a decoupling effect of presumptions of negligence and presumptions of joint negligence when there is discovery errors. Simply, these notations are part of the economic model, but I'll make it, I'll summarize simply. In the extreme case in which you cannot prove negligence, and you are in the traditional regime in which the plaintiff needs to prove the negligence of the tortfeasor to obtain compensation. So you are in a situation in which it is hard for plaintiffs to prove the negligence of the tortfeasor, which means you are in a situation in which it is hard to impose liability on tortfeasors. The simple negligence regime collapses into a no liability regime. The expected liability of the tortfeasor is corroded away, and the tortfeasor expects a no liability. So as evidence adjudication becomes corroded because of problems in evidence, the presumption of non-negligence corrodes a negligence regime into a no liability regime. By using a presumption of negligence, the problem is smaller. The negligence regime is corroded and it becomes a strict liability regime. It's not as bad. The driver knows if I cannot prove my diligence, I'll pay all the time. It's not as bad because we know that strict liability creates optimal care level incentives. Okay, now look at what happens on the victim level. On the victim level, if we have a presumption of comparative negligence or contributory negligence for the victim, and the victim is presumed to be comparatively negligent or contributory negligent, in Italy is comparatively negligent. Under the traditional presumption, the victim says, oh, the tortfeasor will not be able to prove that I was comparatively negligent, so I am entitled to full compensation. And so he will engage or she will engage in moral hazard. Say, I can read the newspaper when crossing the street. Or I can be distracted when crossing the street because the tortfeasor will not be able to prove that. Now, if the victim has to prove that she was diligent when crossing the street, things change. She will have all reasons to be diligent because she has to prove that she was diligent. So they are both threatened with full liability and with no compensation. Is the equivalent of a decoupling system. And that is what the Italian rule is accomplishing with the presumption of joint negligence. That's all I wanted to present.
Thank you, Francesco. Questions? I do have my own question, but okay, I'll jump first. Francesco, maybe if I understood you saying, let me try to sort of rephrase one of the issues you were saying in a different language and see if you agree with me. One of the things you're saying at the end of the day is because of the rules and the way the different legal systems treat adversarial evidence, the problem you have in the United States to a certain extent is that whatever evidence you can get out of these cameras of the new technology, it's sort of a public good because you have to share that evidence with the other side at some point. And so you don't really have a lot of incentives to acquire that evidence because it's a public good, it's a public nature. Whereas in Europe, in particular case of Italy, you're focusing, it's actually a private good, right? I mean, it's a private good nature. It's yours and potentially to our advantage. So you're willing actually to pay. I mean, you're being subsidized by the insurance, but essentially the insurance is willing to pay for that evidence. Is that what you're saying, right? In a different language?
That's exactly so. And so in a mixed regime, so imagine a mixed regime in which you introduce a presumption of negligence and you have discoverable evidence. Okay, who would buy the dash cams? Only those who think are good drivers. If you think you are a victim of bad drivers more frequently than the other way around, then you should buy the camera because you can prove your non-negligence more frequently than being on the other side of the fence with the video camera discovered by the victim. So I would tell my kids, don't put the webcam there. because if there is an accident, most likely you are the tortfeasor, okay? But I would tell my dad, yeah, put a webcam because you are always going 25 miles an hour everywhere and you're a safe driver. Most likely you will be a victim if there is an accident. That is in this hybrid regime where you would introduce a presumption of negligence, but you make the evidence discoverable. I don't know of any regime like that. So interestingly, the European systems that have introduced these presumptions of negligence also treat the evidence as very conservatively as private. Say you have the camera, the evidence is yours, unless we are in those special cases in which the person already knows what is there and it's only a matter of accessing the physical material information that they already know that is there. But you need to tell the judge exactly what you're looking for.
Thank you, Francesco. James, I think you have a question in chat. If you want to ask it directly to Francesco, maybe it's just easier than have Francesco reading the question.
Oh. There is a reference to damage to the evidence. What happens to the victim where the evidence has been destroyed and make it impossible for the victim to subpoena the evidence, like the case of webcam in an accident case. So again, if it is private, I don't know. I don't know how a judge would treat that. So this will be only in those sub cases where you know what is in the evidence. Okay, so I know that in that minute of time you were talking to the kid, and the video would have shown that, and the individual destroyed the video. You know, most likely the judge would construe that as supporting the allegation of the victim. That's my guess. You know, if I was a judge, say I know that at 5:03, I saw the driver turning around, talking to and you have a webcam, and accidentally the 5:03 minute has been deleted or destroyed, I would say this makes the statement of the victim more credible. So that deletion could be used against you. But I don't know of any case that actually has done that. That would be my attitude as a judge. But I'm not a judge.
Thank you, Francesco. More questions? If not, thank you so much, Francesco. We go to Paolo. We have about 30 minutes. So Paolo, take control of the session.
Perfect. Okay, fine. Thanks, Nuno. So just a quick heads up. I was supposed to present, and I wanted to present a paper that looked comparatively at the regime for financial market infrastructure in the EU, UK, and the US. But yesterday, I listened to a few of the panels and about the internalization of comparative law, what role comparative law can play in the years to come. And so I decided to present something different, something I thought about tonight, because also it's like a Friday afternoon at 5 p.m. and like nobody wants to hear about financial markets. So still, I'm going to talk about financial market infrastructure, but I think that the pictures, the framing of the presentation is going to be less technical and a bit broader. Can you see my slides? Fantastic. So what I want to cover in this presentation is the relationship between the financial regulation regime put in place for financial market infrastructure domestically in many jurisdictions, UK, EU, US, after the 2008 financial crisis, and the delicate role that this specific class of intermediaries, that generally clearing houses, central counterparties, central securities depository, and broadening up the definition of trade repository having the market, and how these intermediaries are given access to foreign markets. Because interestingly, over the last 5 years, particularly after Brexit, I think comparativists in financial regulation have played a bigger role, and a bigger role for comparativists in financial regulation, particularly comparatives that care about law and finance and law and economics, can play in supporting more stable cross-border mechanism to give access to markets. Okay, so what I'm going to do in the presentation, first give you a bit of a background, what are this financial market infrastructure, and then I'm going to name a few of them and why they're so important, and they're going to be more important in the years to come. I'm going to then link to the theme of the conference. So like, what is the relationship between international law and comparative law? So the role that international principles are going to play in the regulation of market infrastructure. And then a more narrow analysis of what are the challenges that domestic national regulators are facing when addressing financial market infrastructure. And then the last slide, it's an open question, is like, that can be a stronger role for comparativists in the field because of the presence of a unique regulatory tool, which is called equivalence and subsidiary compliance, that allowed foreign firms to access domestic markets if regulators deem a foreign regulation equivalent to domestic one. So this is like where comparativists can play a strong role in supporting agency. And this is in some way what I've been doing as a member of one of ESMA policy committees, so providing the comparative perspective on the US and the EU regime of clearinghouses. So this works built on some papers that I wrote on international financial regulation and financial market infrastructure. And if you're interested, I'm happy to share those papers with you. But so what is a financial market infrastructure? So this project is going to give a broad definition to market infrastructure. So with market infrastructure, I refers to all those intermediaries that support financial transaction in their lifespan. So, a trading venue, a clearinghouse, a settlement firm, a trade repository, those are firms that support transaction between market participants, reducing transaction costs and bringing clarity and transparency to the markets. A famous piece by John Macy and Maureen O'Hara, they look at the expansion and boom of financial market infrastructure through a Keynesian lens, and they said that financial market infrastructure are those intermediaries that help the transition for bilateral markets to venues, and those are the venues that now support a multilateral relationship. The next line in some way give you two perspectives. One gives you a sense of what are the market infrastructure that operate in the system. So from the point when two buyers and sellers meet on a trading venues, what happened after they execute the contract is clear, then the ownership of the securities and the transfer of ownership of securities is registered, and so on and so forth, what's going to happen to the data of those information. But what is particularly interesting, and this is a new evolution of these markets, what had happened since the early 2000s is that financial market infrastructure now operating large financial conglomerate group, or like what are generally referred to as FMI groups. And this FMI group is just dropping some names: the London Stock Exchange, the Chicago Mercantile Exchange, the Intercontinental Exchange, are large conglomerate where multiple market infrastructure work together, and they're part of the same business unit, and they're part of for-profit, generally public corporations. So these are the big player in the market. So here is just give you a sense of how many, and this is just a selective list of market infrastructure, global market infrastructure that operate in the market. And it wants to show also that the market infrastructure provide services in multiple levels of a financial transaction. So the cash transactions are supported by market infrastructure, derivatives and commodities are supported by market infrastructure. And those firms have seen, particularly after the 2008 financial crisis, they've seen their role being expanded by the intervention of lawmakers that saw financial market infrastructure as trustworthy intermediary whose action were needed to reduce the influence of dealers in the market and provide more transparency and stability and efficiency to the market, particularly derivatives market. So what is particularly interested about financial market infrastructure groups is their global and cross-border reach. There are like the major players in the market, starting from the 2000s, they expanded their activities cross-border. For example, the New York Stock Exchange, or better, the Intercontinental Exchange Group as operation in Europe. But most importantly, the client base, the users base of those firms is international. So when regulators try to address the issues that financial market infrastructure face, they are not only dealing with just purely domestic issue, but the connection and the relationship and the possible indirect consequences of the regulation have cross-borders effect. And for this reason, starting from 2008, we have seen an expansion in cross-border dialogue in how to regulate financial market infrastructure. And just like a quick note that the paper right now doesn't, and the project right now doesn't address, but we are seeing the quick growth of what I call the super border FMIs, those financial market infrastructure that have been supporting the digital asset or crypto assets world. Paxos is a financial market infrastructural group that's a private firm that's been just valued around $2.4 billion. It's still like a small players, but it's gathering a lot of attention as a potential disruptor of the way market infrastructure operate, and Coinbase as a market capitalization that it's larger than almost all European stocks and derivatives exchanges combined. So we are going to see new players coming to the market, and going forward, regulators are going to face new challenges in the regulation and approach to market infrastructure that operate in the digital and crypto world. So talking about the internationalization of comparative law, what is the role that international law, soft or private international law is playing in the regulation of market infrastructure? When we look at the international landscape for financial market infrastructure, we've seen some strong and effective soft rules that have been adopted by global regulators. And the most important, and I think it's one of the best example and most successful example of cross-border international coordination are the principle for financial market infrastructure. The reason why this booklet, this guidelines is particularly important is because truly combine the international aspect of the financial market operation and the more national issues. So simply put, those principles operate as a big umbrella that national lawmakers and regulators have been using to craft their domestic regulation. And what is particularly interesting, in my opinion, is that this international document, so this international principle shared by regulators across the world, have been used as a baseline for comparative analysis of domestic regime when domestic, regulators and lawmakers need to discuss and understand whether or not their peer jurisdiction put in place equivalent regime so that domestic regulators can open up the doors of their market to foreign players. So the principle of financial market infrastructure is a principle-based document that sets some general principle on how financial market infrastructure should operate and how financial market infrastructure and the regulators should think about how to support efficient and stable market. So it's kind of particularly interesting about the principle of financial market infrastructure is that they look both at the micro and macro level of the operation of financial market infrastructures. For example, on one side, they care and they set general principle about counterparty risk, disclosure regime that players should have in place to support transparent access and access to data of financial market infrastructure. So reducing the cost of accessing their services. And on the other side, they have also some like macro and systemic elements in place. So how those firms should operate to reduce systemic risk, how regulators should consider the risk that these firms pose vis-a-vis the network of firms they interact with. So these principles are kind of interesting because they expose domestic regulators and regulators in general to consideration, like truly law and economics consideration on how their approach to FMI should take into account transactional efficiency and systemic risk mitigation aspects. So when the principle of financial market infrastructures were adopted back in 2012, and then particularly focused at that point my analysis to the US and the EU, because back then the UK were a member state of the EU, so there was not an independent UK voice on how those principles should have operated. The biggest concern that domestic regulators faced, particularly the United States, the FTC, were on one side caring about their own internal jurisdiction and the internal powers over their own market, but at the same time they care about being sure that their domestic champions were able to access foreign market in fair terms. So this frictions between on one side protecting domestic interests and protecting jurisdictional prerogative of national regulators, and on the other side still wanted their champions to be given the right to access foreign markets, put for a good 4 years, the CFTC and the European Commission in delicate and tight negotiations on how to go forward. Because the biggest issue that the US and the EU face is like, how do we regulate cross-border issue? On one side, there was the call from both sides to give fair access rules to foreign players, but at the same time, nobody wanted to give up supervisory and regulatory authority over their domestic player and over foreign actors that wanted to access domestic markets. So there was always this tension here in the US, particularly for like extraterritorial application of US law to foreign players. And on the EU, the response was the so-called relocation or location policy. So if you want to access the internal market, you better be authorized and licensed in the EU. So these were a tension that on one side were pulling the sort of cross-border coordination away, despite the need, the call from the industry to having more dialogue and more coordination to have free access to foreign markets. So what is the situation right now? The situation right now is kind of polarized. First of all, it's trilateral situations. The biggest issue right now are between the US, the UK, and the EU. Political wars are on steroid after Brexit, and still and now, as it's been already a couple of months after the formal exit of the UK from the EU, there's still a lot of uncertainty of what's going to be the future of the existing temporary agreement between the EU and the UK in terms of accessing services of financial market infrastructure. What I mentioned, the relocation policies that the European Union is expecting UK firm to comply with, and on the other side, a push from the industry and the UK to have more open border relationships. So the so-called, having stronger passporting agreement with the EU. The financial industry has been pretty vocal in arguing for more coordination and more stability in cross-border regime and cross-border rules, because right now the industry is facing big costs. So it's not just the relocation cost that a lot of firms have been incurring to relocate their businesses to the EU, but the biggest cost that the industry is facing is the cost that it's connected to uncertainty. So what's going to happen? It's going to be a sudden disruption of services because the two parties won't be able to find any agreement on how to go forward, or it's going to be a smooth and clear transition. So right now, it's still very unclear what's going to happen to the FMI financial market infrastructural world. So what solutions are there in place to address this cross-border issue and the cross-border phenomena that financial market have been posed to regulators for the past 20 years? So again, the three options on the table are extreme. So if you put them on the spectrum, they're very extreme. On one side, there is the location policy, which means that if you want to access a market, you better be licensed in the market you want to offer your services in. On a similar extreme position is for a domestic player to claim jurisdiction over foreign players that access the services despite them not being licensed in the host country. And that's, and then there is the third aspect, the one I put in a bit of a lot of hope on, and it's what is called the equivalence determination procedure and the substituting compliance approach. So the way this mechanism works, it was a mechanism that was first introduced, it's been around for a bit of time, but in the financial market infrastructural world, have become central after the European market infrastructure regulation fully embraced it as a possible tool to bring stability and an open cross-border transaction in the FMI world, in some way that gives regulatory authority the power to assess and analyze a foreign jurisdiction regulation and check whether or not the foreign jurisdiction or the foreign regulation can be deemed equivalent to the European one. And if the foreign jurisdiction regulation is deemed equivalent, then a foreign firm can access the European market by complying to their home jurisdiction regulation. And there's a little clause that, this mechanism works if it's reciprocal, so if it's mutual. So if both countries agrees that their regulation and their regulatory framework are deemed equivalent. So what is interesting, and that's again, why I see a bright future for comparativists and why I think, equivalence determination can really support a global and cross-border market, is that we have seen, particularly in the UK, EU relation, but also the US, the early US and EU relation, we have seen a different approach to equivalence. So a different way, like let's say comparativists did their work. And this is in some way connected to political frictions, but at the same time, also in the absence of the shared ground on how to assess equivalent regime. So the early stage where where regulators didn't know and didn't understand precisely, or they were skeptical about opening up their markets to foreign players without them being fully licensed in the home jurisdiction, the equivalence approach, and so the comparativist approach, was sort of line by line assessment. So the EU and US regulators, at that point, it was like 2014, 15, like the CFTC and ESMA and the European Commission were looking at their respective regime for example, clearinghouses, and how line by line they were addressing specific issues in terms of, for example, counterparty risk management, transparency, open access, and non-discriminatory access to FMI services. And that approach didn't go anywhere. It was both parties failed to miss the point of the full equivalence, which is like trying to see if the end result, the outcome of the regulatory framework were equivalent. So no matter how the US and the EU decided to craft their rules, then the two regimes then were going to receive outcome. And the biggest issue, and it's an issue that it's, that some European, like the ESMA has been facing, is the unique regulatory framework the US have in place vis-a-vis financial market infrastructure. So in the US, financial market infrastructures are considered self-regulatory organizations. So they are private regulators and they set their own rules, and there are specific mechanisms that market participants need to follow to amend, adopt new rules. And the CFTC has a final say in the way private actors set their own rules, but it's a soft approach that the CFTC used. So the aspect and this different structure of allocation of regulatory responsibility created a lot of frictions in the early stage of the equivalence. But then starting with the 2017, the US and the EU realized that the equivalence is a work of outcome-based approach. So both parties look at the rules despite how they were crafted, and they look at whether or not they achieve the same outcomes in terms of protecting the interest of market participants, supporting market efficiency, and supporting market stability. And that drove the parties to agree on equivalence determination. And so US and EU financial market infrastructure then now going to offer their services relying on those mutual recognition and subsidiary compliance approach. That's unfortunately not the case with the UK, where while the UK would love to have an outcome-based approach, right now the response of the Commission is to go back to the rule-by-rule approach. So where do I see a role for comparative law, financial regulation comparativist is precisely in support this kind of analysis. Equivalence and subsidiary compliance are not just a financial regulation issue. The Food and Drug Administration, a similar program. So there is a role that comparativists in this field can play in supporting and informing the dialogue that regulators can play in the future. If comparativists are going to focus not just on the formalities of the law or regulation and how those are crafted, but what is the end result on the market, what are the end result on how market participants operate in the system, then the work of comparativists can support regulators and provide guidance to regulators in putting in place this new mechanism to support cross-border trade. So I'm going to stop here. It's 22 minutes, so it was a bit too long. So if there are any questions, this is a project, it's not a clear paper. I wanted to go a bit broader. If you have any advice, any suggestion, they're more than welcome. Yes, Nuno.
So my question is a bit, I think it's a great project. I think you have a lot of issues to look at. So I'm going to start with the big picture. Isn't the big picture that when you look at this is a bit like any other area. And you have heard me asking this question to you in different formats. So let me do a new format. Isn't this the same as most areas in international politics or relations, anything that is transboundary, where you have two sort of models to address this. One is pure anarchy, right? There's no such thing that there, each one for himself or herself, in this case for itself, since it's a country. And this worked for a long time, as long as the United States, and to be, United States plus European Union, but if you're the United States, were sort of kingmakers. They ruled the world, they rule the financial world. So why not anarchy, where the West imposes their rules and everybody else follows, and that's the way it works. And maybe we have some minor conflict between EU and US, but that's certainly not the big issue here. The problem is we are in decline, the US and the EU. So we now want the soft law. We want international organizations to come in and sort of addressing this problem for us. Because we are all very concerned about China and how China is going. I know you didn't talk about China, but how China is going to change financial markets, shape financial markets, if this is unregulated, if we don't do anything about it. So my question is, in your story, where does China fit? And is China one of the driving concerns of the US and the EU right now in terms of international regulation of financial markets, and where do we go from there?
I think I'm going to ask Leisha to ask a question about the China point is great. I was attending a conference 2 days ago where I think the vice chair of the Chinese federal, the equivalent of the central, the Chinese central banks was speaking, and he said something like, if the US are going to stop our firm to list on the on the New York Stock Exchange or NASDAQ, then we're going to look at the EU as our next capital markets partner. So you can see China playing a kind of interesting role, potentially interesting role, and re-challenging their capital somewhere else. London is in desperate need of new capital. Like, there are kind of some statistics that I recently see about the London Stock Exchange losing, and like there was I think an Economist article in this most recent Economist about the London Stock Exchange losing in massive market shares in global issuance of new stocks. So that can be an interesting role that it can play in terms of like other small financial centers. And this is like the trilateral relationship. You can see like how the EU still care about the smaller center and have equivalence agreement with smaller center like Singapore, Australia, and this kind of thing. And so, and it's all based with equivalence. But like the China point is very interesting. And I think they are holding, it's a kind of delicate, I think Paulo Farah was here, the expert on China. But it's an interesting point. Lecha.
Yeah, so it is related to Nuno's question, because Nuno is talking about China, but I bring it down to methodology in the sense that, so you're taking an international approach to global FMIs, right? So what I am missing is a framework somehow that ties everything together, right? On the one hand, you have what we define as international, but then the global side of it, right? The interconnectedness, the domino effect, right? That makes us think about huge players like China, right? Is not really tied in, right? So it almost feels like everything is international, but we're missing this interconnectedness, the domino effect that brings in other jurisdictions. So that was one of my comments. And then, coordination, problems of coordination, isn't this a question that we have gotten used to deal with when it comes to EU, for example, right? So is it just a question of access to the market? Or is it a question of how much you can get out of the market? How much is the slice of your pie, right? And for that, I think it's important to realize that the EU and the US have different approaches to markets. They think differently about what a market is, right? And so for your research, I think that context should be somehow enhanced, right? Because the conversations and soft law and whatever mechanisms that are found to make these parties to talk will have different implications. They should work for both, right? And the fact that they have different perspectives of the market is important. So these are my two comments. The methodology that allows us to really make a distinction between what's international and what's global, and the actors or countries that should be considered. And then, when we're talking about problems of coordination, what are we really talking about? Just access to the market, or how much of the pie the countries want to have, right?
Perfect. Thanks.
Paulo, there's a question in chat by James.
Yeah.
I would say just give it a look, and then just respond to everyone, because we have about 2 minutes.
Yeah, globally, you didn't make any reference to international legal framework or bilateral agreement, or is there no legal framework to relate FMI, more particularly in the area of governance? So I think, try to tie together, and thanks, James, for the question. Try to tie together later and James. So starting from James' point, I didn't talk about all the international guidelines and soft rules that have been adopted by many international agencies. So, the Financial Stability Board is coming out with came out with a multiple set of principles that FMI should, that should inform the action of domestic rulemaker in regulating FMI. So there is a big component of soft law guidelines, principle, and agreement that builds on top of the general PFMI. The PFMI are just like the very big umbrella, and under that, the Financial Stability Board and IOSCO have been adopting multiple layers of regulatory frameworks. So like, yeah, this is a good point. And Alicia, your points, I think like, you know, they're a great point. Like, what is the framework? So my kids just got back from daycare and they're asking me to go out and play. But the aspect, you know, the comparative, so the 2 points, so the framework, yes. I talk about international, and then the conversation after ended up being US, EU, UK. So there are like a lot of, and that's something that I should spell out way better in the paper, because there are a lot of other international markets, international player within the Financial Stability Board and G20 that, yes, are like other big countries. The interesting aspect is that sometimes those markets are not international in nature. So their domestic players do not access, they don't provide services to foreign players and so, or cross-border services, which makes the, you know, the expanding the analysis say like, yes, you are there as well, but it's less relevant. But like, you're right, I should expand a bit more on equivalence with other countries that are, you know, not just the EU and the US. Like, there is a good list of other foreign countries that the EU and the US have equivalence agreement with. And in terms of, you know, markets and pie, this your last point is just in terms of giving access. No, like the interesting aspect that should develop a bit better is that those international framework do not just care about, like, you know, expanding the pie. It's an aspect of, you know, creating a supervisory framework and some coordinating agreement on how to address some of the issue that we faced back in 2008 when we had international financial institution that collapsed in the US, and because the lack of coordination in place between supervisors, some European peers could not handle the failures because all the assets were trapped in the US. So like it's a multi-level aspect, and it's not just a regulatory perspective, but also a market perspective. So market participant in some way wants clarity of rule so they can better internalize their compliance costs. So it's kind of a multiplayer, multi-level dynamics. But like, thanks a lot for these questions.
Thank you all. So I'll conclude our session. I know we are the 7 last Mohicans in the group. We were up to 14 people at some point, so let's not get desperate. It's only 50% down. And thank you all. Thank you, Alessia. Thank you, Francesco. Thank you, Paolo, for being here. Thank everyone to be here. And hopefully next year, the conference will be live and we'll can be able to go out for a coffee or a beer after the session. Take care, all of you. Thank you so much.
Thank you.
Ciao.
Ciao, Bruno.
Ciao. Buon fine settimana.
Grazie, ciao.